Hi, today I am going to share with you about a recent decision of Honorable Supreme Court in Rava Sahib versus State of Karnataka, wherein Supreme Court made an interesting observation pertaining to drafting of a criminal complaint for the police by an advocate. Now, when a criminal complaint is filed, the role of an advocate starts. If the FIR is registered, the role of an advocate starts only if the charge sheet is filed, that too for the accused. Because once FIR is registered, the complainant is given a status of de facto complainant, and state of Karnataka becomes, or any state becomes, the complainant. So the state investigates at its own expense and files the charge sheet or closes the complaint for whatsoever reason it may be. Now, what happens if an advocate drafts a criminal complaint? What is the difference between a complaint that is drafted by an advocate and a layman, or a victim, or a complainant? The major difference between the complaint being drafted by an advocate and the victim is the attention to detail. When advocate drafts a complaint, because he knows what happens in the trial, what happens in the investigation, there will be more attention to detail. He will give more importance about time, he will give more importance about place, witnesses. The complaint is drafted such a way that police cannot escape. That is why the complaint that is drafted by an advocate will invariably be looked down by the courts, because they can easily identify, even the police and the courts can identify a complaint that is drafted by an advocate as a ghost. Now, in this case, advocate drafted a complaint. Advocate appeared as a witness on the ground that the complainant is illiterate and cannot sign, and can sign only by way of a thumb impression. Therefore, the draftsman was an advocate. He signed in the complaint as he drafted the complaint, and he was called as a witness by the prosecution. He spoke in favor of the prosecution. And what are the conditions? Now we must understand what are the conditions where advocate can draft a complaint. Now this condition is a condition where the complainant is illiterate and can sign by way of a thumb impression. This is one condition. There could be other conditions also where the victim is unconscious and the complainant could not express properly. The victim could be a child. There could be many circumstances. Now what we must understand here is that what are the circumstances where the draft of a complainant, of the complaint by an advocate is approved by courts, is approved by police. Simply, if a complaint is being drafted by an advocate, police gets doubt. Now when the complainant is cross-examined as a witness, definitely he will fall flat, because whatsoever the complaint is made, because when the complaint is given by a complainant or a victim, it will be more of emotion and less of detail. But if complaint is drafted by an advocate, there will be more of mind, more of detail, less of emotion. It will appear like a premature charge sheet. That is how an advocate drafts a complaint. There will be more attention to detail. So that is why when a complaint is drafted with so much of detail, there will be a doubt casted upon the complaint and the case may go wrong. The case may fall flat. Therefore, if the circumstances are favorable, if the circumstances speak in such a way that it could be drafted by an advocate, it could be drafted other than anybody who is not a victim, who is not a complainant. If the circumstances are like that, victim can be unconscious, victim can be a child, victim can be illiterate. I'm giving for the purpose of illustration a couple of examples for the purpose of illustration, but are not limited. The circumstances could be fresh. Then the criminal complaint drafted by an advocate is valid in the court of law. If the circumstances and the conditions do not favor, please remember, entire case falls flat if it is drafted by an advocate. Hope I'm clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.